All right. Good evening. Hello, Facebook land. All right. Good evening. Hello, Facebook land. All right. Good evening. Hello, Facebook land. Okay, I've turned off my echo. Hello. Welcome everybody. It's 7 p.m. tonight, and you are watching us here on this live event where we're going to be discussing tonight navigating spousal support laws and practicalities in New York State. So welcome. I want to introduce myself. I am Deborah Whitson. I am an attorney with 30 years of experience. I'm also trained as a mediator in family law and in solutions.
Hello, everyone. Thank you for joining us this evening. I'm a senior associate at Whitson Law, and I've been practicing law for about 6.
All right. Thanks, Wendy. I'm so glad that we're together tonight, even though we are clearly not together in the same space. But that's the beauty of digital tech license to practice law in New York State. And so for the focus of our topic tonight, we're going to be explaining New York law as we understand it. So a couple of things to point out here before we go. This is the legal disclaimer part. You know, we're lawyers, so we're going to have to do that. So this is not intended to be giving you specialized or particular legal advice about your situation. Of course, if we haven't met you and we haven't learned the facts of your situation, we clearly can't give you legal advice specifically for you. So this is for information only, and we do strongly encourage you to schedule a consult with an attorney of your choosing. If you're in a different jurisdiction, you're going to want to choose an attorney in your state. If you're in New York, we would be happy to set up a consultation with you. Don't hesitate to reach out. There'll be information at the end of this about how you reach us. But this is also not creating any that are taking you on as a client. So hopefully this will just be a ton of really good, useful information that will give you a starting point for understanding your rights and your options. And then you'll take it from there and get individualized advice from somebody else. So with that being said, I want to tell you that the format tonight is that Wendy and I will be taking you through the basics of understanding how to navigate through the legal system in New York. If you think you're entitled to spousal support, if you think you might be obligated to pay spousal support, or you're already in that situation and you have questions about whether or not it can be adjusted or changed or stopped. So we'll be arming you with some information, and we also have invited those of you who pre-registered to submit questions in advance. So things that you've been dying to know about, maybe that's the reason you're here, is you have a specific issue you would like an answer to. We're going to cover all those. And if you are joining us without registering, or you forgot to submit a question, or you think of one along the way, feel free to type that in one of two places. If you don't care about anonymity, you can type it in the thread beneath the live, and we will make sure that we see that and get a chance to answer it. If you choose to remain anonymous, and we totally understand why that might be, you can put it as a private Facebook message on the Whitson Law Firm Facebook page where you're watching this live, and we will protect your anonymity and we'll just answer your question without saying who submitted it. And so none of the questions submitted previously or during the live will identify the questioner unless you choose to put it in the thread beneath the live feed. So with that, I know you're here to get the information and the value that you signed up for. So we're going to start off with Wendy taking you through some of the important basic information you need to know about this topic.
All right, let's get started.
Yeah.
To begin, let's talk about what is alimony, what is spousal support, what is spousal maintenance. Sometimes these terms are used interchangeably and are often a bit confusing for everyone. However, alimony is a type of payment that the court orders one spouse to pay to the other spouse for his or her reasonable needs throughout divorce proceedings or after divorce has been finalized. In New York State, a married person may be legally responsible to provide for the support of his or her spouse during the marriage if that spouse lacks sufficient income or assets to provide for his or her own reasonable needs. In New York Supreme Court, alimony payments that are made while a couple is divorcing are referred to as spousal support, while payments that are made after a divorce is finalized are known as spousal maintenance. So Some people use it loosely, but this is what it means. The spouse who pays maintenance is commonly referred to as the payor, and the spouse who receives maintenance is commonly referred to as the payee. For spousal support and maintenance, the payor is the more moneyed spouse, so whose income is greater, which is, again, the spouse with more income. In New York family court, alimony payments are referred to as spousal support. So let's now talk about what is the purpose of alimony, right? We all want to know why the court awards alimony to the other spouse. So the purpose of alimony is to provide support for one spouse to allow them time to become self-sufficient financially. For example, sometimes when parties have children, one spouse decides to be the stay-at-home parent while the other one works full-time. Here, the stay-at-home parent would be the spouse seeking spousal support since they have been dependent on the spouse that was working full-time. Alimony will allow the stay-at-home spouse time to become self-sufficient. Self-sufficient meaning able to seek employment and what is required for certain employment, such as education, training, certifications. Another example may be when there is a great disparity in income, such as when one spouse makes substantially more than the other throughout the whole entire marriage. And there's also, different types of alimony in New York. Two of them actually. The first type is temporary maintenance. Temporary maintenance, this may be referred to as pendiente lite maintenance. This type of alimony is often awarded while the divorce is pending in court. And then it stops when the final divorce decree is made by a judge. The award is based on actual spousal need and is set based on predetermined statutory guidelines that we're going to discuss. And these guidelines help to determine the amount needed, which we will discuss in a bit. The second one, the second type of post-divorce is post-divorce maintenance, sorry. This type of alimony is paid after the final divorce decree is made. The payments are determined by the length of the marriage, how long you've been married, and take into account income of both spouses. Similarly to temporary maintenance, there are statutory guidelines that help to dictate what baseline support might look like. If it is decided that alimony should be paid, the court could order payments both on a temporary basis and then as a post-divorce maintenance. The award of one does not negate the order of the other. So just because you got awarded temporary maintenance doesn't mean you're going to get awarded post-divorce maintenance, vice versa. What qualifies, right? What qualifies as maintenance, you may ask? New York Domestic Relations Law Section 236B1A defines maintenance as the payment of money from a current or former spouse to the other pursuant to a written agreement or a valid court order. So in order to qualify as maintenance, there must be a payment in money, which may include a check, a money order, wire transfer, or any other means to transfer cash. The payments must be between spouses or former spouses, not third parties. The payments must be made pursuant to a written agreement or court order. So voluntary payments do not qualify as maintenance if there is no such order or agreement. For example, let's say the husband gives wife money for rent. Is that rent money considered maintenance? The answer is no, because there was no written agreement or court order. It was completely voluntary. This we see a lot. Can you receive spousal support if you have not filed for divorce? Let's say you're legally married, you're not living with your spouse, and are not yet in the process for divorce. Here, you can seek spousal support in family law, in family court. And I know Deborah's going to speak more in reference to how spousal support works in family court as opposed to in Supreme. Another example where you can seek spousal support in family court is when the parties are living in the same home and one spouse stops contributing financially to the household. This we don't really see often, but sometimes every now and then it comes around. So what happens if you have a spousal support order from family court and now decide to proceed with a divorce in Supreme Court, right? You start your petition for spousal support in family court, and, you know, the court enters an order, and then you say, okay, I'm just going to file for divorce. So here, the spousal support order from family court may be incorporated. In other words, will continue. That's what the word incorporated means, into the divorce action in Supreme Court. And a spousal support order from family court ends when a divorce is actually granted. And only Supreme Court can order spousal maintenance in a divorce to continue after divorce. Now, for that $1 million question, drum roll, how long is spousal maintenance paid, right? How much do we have to pay our spouse, or how long can we receive it? Spousal maintenance is normally durational. That is, it has a set duration, normally long enough for the payee spouse to become self-sufficient. However, there are cases, given age, health, inability to support themselves, that the payee may be awarded non-durational or permanent maintenance. To decide the duration of spousal maintenance, the judges may use an advisory schedule provided by the state of New York. And this advisory schedule lists the percent of time the couple were married as a guideline for duration of maintenance. So just as an example, I want to put the first slide up to show what this advisory schedule looks like. Okay, here we have it. So the maintenance law, effective January 23rd of 2016, sets forth the advisory schedule which the court may use to help determine the duration of post-divorce maintenance. Let me give you an example of how this advisory schedule works. Let's say Jack and Jane have been married for 12 years and 0 months. So the date of marriage is July 27, 2011, and the date the divorce action commenced, also known as the cutoff date, which I just, for the purposes of this example, I put today's date. The guideline duration is based on the length of marriage. There are 3 categories that the court looks at. First, marriages between 0 and 15 years equals 15% to 30% length of the marriage. Second, marriages between 15 through 20 years equals 30% to 40% length of the marriage. Third, marriages more than 20 years equals 35% to 50% length of the marriage. Now, how do courts determine spousal maintenance? Let's turn to our second slide, which will show the 2 formulas the court uses.
I just want to point out here that at the bottom of this slide, you have provided how long this spouse would be potentially receiving spousal maintenance from the payor. So it's in a range of 1 year and 10 months to 3 years and 7 months. That's a pretty good range, right? It's a big difference between those 2 numbers. Just pointing that out for everybody in our audience watching this.
Thank you, Deborah. So, okay, so in our second slide, a judge will begin the determination of spousal maintenance amount with one of 2 statutory formulas, depending on whether or not child support will also be paid. In New York, spousal support and maintenance is determined by a guideline calculator based upon the income of the 2 parties and the length of the marriage. So those two things, the income and the length of the marriage. The court is allowed to deviate from the guideline amount based on a number of potential rebuttal factors. However, such deviations are very rare. The calculation the court uses is set forth in this slide. As you can see, the parties are allowed to take certain deductions from their incomes for various qualifying tax expenses, such as state and city income tax and FICA taxes, such as Medicare and Social Security. The support maintenance amount is the lower of the 2 results between 1, 30% of payer's income up to and including an income cap, which is currently at $203,000, minus 20% of the payee's income, or the payer's income up to and including income cap plus payee's income equals total income. And then you do 40% of the combined income and subtract the payee's income from that. Right about now, I probably lost everyone. It's kind of complicated to understand, especially if this is the first time you ever see it.
I'd like to mention that we can share these slides in the thread below the live, and if you've registered, we're going to email you a bunch of stuff afterwards, so you'll be able to take these out and play with them on your own. You don't have to take copious notes.
And most people are understandably confused by this complicated math. Even sometimes I'm like, wait, I have to do this over because these calculations are not correct. That's why we have our calculators, which are the best. So also in our second slide, I have set out an example for you to better understand these formulas. Let's use Jack and Jane again. Jack is married to Jane and the two have no children together. They've been married for 12 years. Jack earns $80,000 per year and Jane earns $20,000 per year. After deductions for taxes, as previously mentioned, Jack's adjusted income is $71,277.28 per year, and Jane's is $18,164 per year. If we look at Formula One, under Formula One, maintenance would be $17,750.38 per year. And under Formula 2, maintenance would be $17,612.51 per year. So Formula 2 is the lower of the two formulas. So the guideline maintenance would be $17,612.51. That could be paid monthly, bi-weekly, or weekly based upon the party's agreement or at the judge's discretion. Also, sometimes it's based upon how the party is paid at work. As to the duration, the parties are in category 1. 15% of the length of the marriage is 1 year and 10 months to 30% of the length of the marriage, which is 3 years and 7 months, which is the guideline durational amount. Thus, under these guidelines, in our hypothetical scenario, Jack should be paying Jane maintenance of $1,467.71, which is the lower of the two formulas. And that is for a duration between 22 months to 43 months. And again, this is totally discretionary upon the court. The court can, determining, we're going to go over the 15 factors. The court also looks at the 15 factors, doesn't have to determine what would that amount be. There is a cap on the payer's spouse's income in the formulas, as I mentioned before. But if the payer's income exceeds that cap, the court may adjust the amounts and length of time that maintenance is awarded by looking at a number of other statutory factors in order to arrive at a just result. So let's now turn to our third slide, which shows the 15 statutory factors a New York judge may consider. And so these statutory factors are: 1, the age and health of the parties, the present or future earning capacity of the parties, including a history of limited participation in the workforce, right? Sometimes you have the stay-at-home mom or the stay-at-home dad, and you have the other parent working or earning a degree. The third one is the need of one party to incur education or training expenses. The fourth one is the termination of a child support award before the termination of maintenance award, when the calculation of maintenance was based upon child support being awarded, which resulted in a maintenance award lower than it would have been had the child support not been awarded. The fifth one we see here is the wasteful dissipation of marital property, including transfers or encumbrances made in contemplation of a matrimonial action without fair consideration. This is a big one that I see a lot. We see a lot of this where the parties start dissipating assets, they start gifting things, and then you're like, where is the money? And then they don't even list it on something that when you have to disclose your financial circumstances, sometimes they don't list it because they got rid of it, either in contemplation of marriage or after. So the sixth one is the existence and duration of a premarital joint household or a pre-divorce separate household. 7 is acts by one party against another that have inhibited or continue to inhibit a party's earning capacity or ability to obtain meaningful employment. Such acts include, but are not limited to, acts of domestic violence as provided in section 459A of the Social Service Law. 8, the availability and cost of medical insurance. 9, the care of children or stepchildren, disabled adult children or stepchildren, elderly parents, or laws provided during the marriage that inhibits a party's earning capacity. The 10th one is the tax consequences to each party. 11, the standard of living of the parties established during marriage. 12, the reduced or lost earning capacity of the payee as a result of having forgone or delayed education, training, employment, or career opportunities during marriage. This is also a big one. The 13th is equitable distribution of marital property and the income or imputed income on assets so to be distributed. 14 is the contributions and services of the payee as a spouse, parent, wage earner, and homemaker, and to the career or career potential of the other party. And last but not least, any other factor which the court shall expressly find to be just and proper. And that usually applies to the case, a specific case, the court looks at that factor. Now, what must you show the court about your finances and property, right? You file for divorce, the other side gets an attorney, and now the litigation begins. So both parties must be completely transparent about all their finances. Don't try to hide assets. They're gonna find out, and it's better to lay it all out right when you start. Because then, the court, if the other side finds out, the court starts casting doubt on you and your finances, and sometimes it just works against you. So it's always good to be truthful from the very beginning. And you don't want to make your lawyer look bad either. They will provide sworn statements of net worth and financial documents, right? You would have to provide things like your income tax returns, health plan information, representative pay stubs, bank account and credit card statements. This is very important. One of the especially when imputing income or when a spouse is self-employed. That's we really, I look at that when it comes to discovery, the bank accounts, because sometimes, one party is self-employed or they get paid cash, and it's difficult to really track how much you make, because a lot of people, go to their accountant or their tax preparer and don't disclose the real amount of income they're actually making. So we ask the court to impute income, and the way we show the how much income the party's actually making is by looking at his or her expenses, and going through the bank accounts and credit card statements. And sometimes we see a lot where these credit card statements show that, their expenses exceed their actual income. So this is a red flag where we say, hey, wait a minute, like, you have all these monthly expenses, yet you're claiming $10,000 on your income tax return. Something's wrong. So this is when we attack that, and we say, hey, court, please impute income and base his income I say his, but his or her, based upon their actual expenses. How much money do they spend or say they spend versus what they claim as their income in their income tax returns. So other things are titles, like property titles, vehicle titles, other documentation regarding property. The court will also set aside a date for the valuation of the assets at some point before trial during the process of discovery, during which both parties exchange financial information. A lot of people ask, can I go to court to get the amount of spousal maintenance changed, or to ask the court to end it because they just don't want to pay any more spousal support? Some people feel like, oh, I only want to pay child support. Why am I paying spousal support? Well, yes, you can get a modification of spousal support later if the court determines that an extreme change in circumstances warrant it. An extreme change in circumstances may be when a spouse loses their job, of course, through no failure of their own, or when a party becomes disabled. So this is a broad overview of many of the questions we've received from our audience, and I hope I've answered most of them. And at this point, I'm going to turn to Deborah for further discussion on these important issues.
Wendy, that was great. Thank you so much. That was a lot of information. So I want everybody again to just be rest assured that we'll be sending you a lot of resources. If you've registered for this event and we have your email, you're going to get an email of the recording and lots of other things, but we're going to put as many links to resources as we can think of that are helpful to you, so that you can continue to explore and educate yourself beyond this. And I do, again, reiterate, I invite you to schedule a consultation if you are based in New York and want more personalized guidance or advice on this situation or this topic. So I wanted to talk about a couple of things that Wendy alluded to. So in New York, you may or may not know that we have a family court system and a Supreme Court system. And the Supreme Court handles everything that you can think of, every type of, it has jurisdiction over every type of legal matter. And that would include things like child custody and child support and family support or spousal support. But Supreme Court is the only place you can go in New York to get a divorce. It doesn't share that custody with any of our other courts. Family court exists to be a more accessible, affordable, informal, and user-friendly place for people to go to address things like custody, family protective orders, child support, and even spousal support. So I've already alluded to, it's a lot less formal than Supreme Court. There are no filing fees or court costs or motion fees associated with any family court matters. There are fees to file and start an action and make motions and have a judge intervene in your case in Supreme Court. So there are a lot of people, or a lot of reasons people might want to access the family court system if they only wanted to address issues arising out of a marriage or a long-term partnership where there are children in common, but they're not eligible to seek a divorce because they were never married, or they're not interested in that moment in seeking a divorce. So sometimes that's referred to the family court and Supreme Court having concurrent jurisdiction over certain topics. So for our purposes tonight, family court does have some concurrent jurisdiction over spousal maintenance or spousal support, as well as child support. And sometimes those go hand in hand, and somebody is filing for both forms of support in the family court. So who can access the family court, and why would you access family court as opposed to Supreme? So if you've never been married, let me say that, and you have children in common, you can access family court for custody and child support. But if you have never been legally married, you cannot, you're not entitled to seek spousal support because you were never officially a spouse. So that's a thing to consider if you are in a long-term cohabitation relationship and you are operating, as many married couples do, where one party might be a stay-at-home spouse or a stay-at-home parent, or a part-time outside of the home working parent, while the other is more of a breadwinner. If that relationship breaks down, you don't have the opportunity to ask for spousal support. So those are great situations to consider a cohabitation agreement. And I'll talk more about where you can learn about cohabitation agreements if you find that's your situation and it applies to you. But if you're married and there's no desire to get a divorce, or there's no desire at that moment to pursue divorce because that's a lengthier process and perhaps a more expensive process, and you are in need of spousal support, particularly if there's a recent breakup and you're now living in separate households and you cannot support yourself in your own separate household, you can access the family court by filing a relatively informal petition for spousal support. And I have already mentioned that the family court forum has less formality and less stringent rules. So Wendy had alluded to the fact that in Supreme Court, there are two specific kinds of maintenance. One is called temporary maintenance. That's while the action for the divorce is hanging out in the court system until the divorce is finalized and granted. That can be a few months, and for some unfortunate families, that can be several years that the case is hanging out in the court system. And then after the divorce is entered, there can be post-judgment maintenance. But since there's no divorce at play, if you're filing in family court, because you can't seek one there, you can get an order of spousal support if you qualify. And that order will remain in effect until changed, or until somebody pursues a divorce action, and it would terminate at the time the divorce action is commenced or a judgment of divorce is ultimately issued. So the formulas that Wendy set forth for you earlier, they are accessible to the magistrates and the family court support parts as guidelines, but they're not as strictly adhered to. And we don't have those 2 periods of temporary maintenance and post-divorce maintenance, which are different formulas and they're applied differently. So it's much more straightforward. There's more flexibility for the magistrate or family court judge to deviate from the guideline formulas. And some parties choose to go it alone without attorneys. And while the family court personnel and the presiding judge or magistrate in family court can't give either party legal advice, there's a lot more hand-holding that goes along with being in the family court system. If you choose to be unrepresented or you might be able to apply in that forum for representation if you income qualify for free or reduced cost representation in the family court forum. So if divorce is not something you're contemplating in the near future, family court can be a great, efficient, easy way to get yourself an award of spousal support. And if you have a family court award of spousal support and nobody is pursuing a divorce yet, that's the place where you would return to have that award adjusted, modified, or terminated, if that's the only award, order that's been in effect concerning your family support. I wanted to talk for a second because it comes up always in the questions, and Wendy showed us, we showed a slide what Wendy was describing, the factors the court will consider. And one factor the court will consider potentially in evaluating the amount and duration of spousal support in Supreme Court is the tax consequences to either party. So another disclaimer here, neither Wendy or I are tax attorneys. We are not tax professionals. We don't even play them on TV or on Facebook Live. So we are matrimonial and family law attorneys, and we know enough about the tax law to steer our clients to seek outside tax advice on issues surrounding separation, divorce, and child and family support. But I do want to tell you that our understanding of the current laws about the taxability of spousal support payments, and I'll mention child support too, because there's often a question about that. So the law is now different at the federal income tax level versus the New York State level. And again, we're talking only about New York State law and New York State issues here. So at the federal income tax level, right now, the current status of the law, as we understand it, is that the payor doesn't get to deduct from his or her taxable income the amount of spousal support paid to the spouse or former spouse. So if in Wendy's example, Jack and Jill, Jack paid $1,700 a month over the course of a year in spousal maintenance, he doesn't get to deduct that from his taxable income on his federal return. And the opposite side of that coin is when Jill files her federal personal income tax return, she doesn't have to claim that receipt of money from Jack as income to her. So it's a really nice thing for Jill. She gets income that's free of taxation to her. And Jack, poor guy, he's going to pay the tax on that money that he's sending to Jill's household. So that's with spousal maintenance or spousal support. In New York, Jack can deduct that from his New York personal income tax. So he's paying less New York tax on that income he's earned. And then that money he pays to Jill is taxable to her. So she's going to have to report that as income on her New York tax. And in all likelihood, unless she's planned ahead and met with a tax planning consultant, if she hasn't put aside money for that, it's going to either reduce her typical refund on her tax return for the state, or she may owe money to the New York State Treasury Department for that spousal maintenance income that she now has to pay taxes on. So that's something to think about if you're in New York and you're filing New York personal income taxes. But in the federal land, Jack pays all the tax on all of his income and for family support purposes, and Jill gets that spousal maintenance from Jack without any tax impact to her at the federal level. Now with child support currently in New York and under federal law is taxable to the payor. That income that he's earned before he pays the support over to the other parent is taxable to him, and the recipient of child support receives that without any tax obligation for that additional income coming into the recipient or payee's household. So child support is handled the same way at federal and state level, and there's that slight difference in New York State with spousal maintenance being taxable to the recipient for New York personal income tax. So if we haven't already caused your minds to go, because this is a lot of financial information, I'm sorry, that may have pushed you over the edge, but we think it's important for you to at least be introduced to that concept. If you're not clear on how that would impact you, get some personalized advice, and consult your tax professional if you think you're have an issue about paying or receiving spousal maintenance and not sure whether it's taxable to you or not. Okay, so I think that we've come to the end of the presentation portion of this, and we have left time here for questions. And I think that in covering the topics that we've covered, a lot of the questions that have been submitted in advance have been covered, but I'm going to quick run through the list just to make sure I haven't missed anything. So there are a few that I think we didn't hit head on. So someone asked, can I get spousal support if the judge only awarded me child support? So yes, potentially, but remember, you can get child support awarded to you if you were never married. So you have to be, spouse or former spouse to be entitled to spousal support. And you have to have that difference in income. So you have to be the lower income earner in the situation. Even a higher income earner can be receiving child support from a non-custodial parent who earns less. So in spousal support, only the higher wage earner potentially pays to the lower wage earner. So you have to have that income differential to be entitled to be awarded spousal support. And then the court would have to consider the interplay between how much child support is being paid and how much spousal support is being paid, because we can't take the payor below a reasonable level of available income in their own household for their self-support or for the time that they might have children in their partial custody, for instance. So the court would be looking at an interplay of what is, based on these formulas, what is the right amount of support if they're going to combine or award double spousal and child at the same time. Someone asked, can I get spousal support if my partner has had an affair? And then let me just say that that's painful and that's unfortunate, and it may raise a lot of emotions and maybe even feelings of anger and retribution, but affairs have no bearing really on shifting support obligations, equitable distribution awards, or how property is divided in a divorce, etc. So I know a lot of people think that, well, that person was a real jerk and broke up the marriage because they had an affair, but that really has no place for divorce or family court judges to be considering that conduct or misconduct, if you will, as an influence to how much support is paid, if any. So I hope that answers the question. It might not have been the answer you wanted to hear, perhaps. Someone asked about a court using something they called a disso master, and I'm going to guess that that's a dissolution master online tool to calculate spousal support. So while I have not had personal experience with that, and I am just assuming that that's some sort of online tool, you would need to check if this disso master tool applies in your jurisdiction, because every state has its own rules about spousal support and child support for that matter. So in New York, we don't have a disso master that I am aware of. There are some private programs or apps that lawyers use to run their own internal calculations for spousal support for their cases. But there is an online spousal maintenance and actually an online child support calculator available through the official New York State Court website. And so we will be posting a link to that, and you can try that out. You can plug in different income numbers and see how the results come out. It is pretty user friendly. But bear in mind that that is a guideline and not a hard and fast rule. The court always has room to sort of deviate and make adjustments or go higher or lower than the result that you get out of those calculators. Let's see. What if my ex-spouse fails to pay the spousal support order? So that's a great question. So if you have an ex-spouse, we are going to assume you have a Supreme Court order based on your judgment of divorce. So with a Supreme Court order based on a judgment of divorce, even if it incorporated an agreement that you and your ex-spouse reached about the amount of support or the duration, if someone is not complying with an order and or an order that incorporates your voluntary agreement about support, you have the option to file a motion to compel enforcement and to hold the other party in contempt of court, because failing to follow an order is contempt of a court order. So that brings lots of potential consequences for you and for the person who's alleged to be in contempt. So if you establish that the person is in willful contempt of an order they had knowledge of, they can be punished with monetary sanctions, with an award of legal fees to cover your legal expenses and out-of-pocket expenses for pursuing that motion. And if it's really, really serious and egregious and like outrageous conduct, let's say it's the 5th time you brought somebody back to enforce an order that they're willfully violating, they could potentially face incarceration for continued violations or egregious violations of a court order. So it is pretty serious, and you do have remedies if someone is failing to pay. Now, bear in mind that if somebody quite literally does not have the capacity to pay an order, that could be a defense. So they have to be able to, they have to have the means to pay the order. But quitting your job or giving all your assets to your new girlfriend or your new wife, it's not a legitimate way to say you don't have the means to adhere to an existing order of support. You're probably guessing that there's a fair amount of gamesmanship that can sometimes arise in these cases, and Wendy and I have probably seen just about all of that stuff.
Deborah, I just wanted to interject also, there's violations as soon as there may be violations to the DRL notices. So the DRL notice is basically a notice that's attached to the summons, which basically says the parties need to refrain from transferring assets, dissipating assets, things like that. So as soon as they get the summons and complaint, they cannot, do any of those things. And if they do, then the other party can file a motion right away because they would be in violation.
Right, that's a great point, because in New York and maybe in other jurisdictions there's similar things, but the minute you start an action and the other party has served the papers, they're served a notice, an order that says, basically we call it the rules of good financial behavior, that you can't mess around with the finances, you can't sell, give away, destroy, hide assets, you can't run up debts that are not in the ordinary way that you've handled your finances. So you can charge your gas to your gas card or your credit card, and you can charge your groceries, but you can't run up unusual expenses or extraordinary expenses, etc. So it's the rules of good financial status quo. You can't change beneficiaries on life insurance policies, pension accounts, retirement accounts, etc., while the divorce is hanging around in the court. So beware of that. If you are served with papers and you're in New York, those rules are going to apply to you. And if you are the person starting the divorce action and serving the other party, be sure that you alert your attorney if you have any indication that some of that mischief is going on across the aisle, because you're going to want to shut that down and bring it to the court's attention and get sanctions and shut it down before it's irreparable, because sometimes when those things are done, they're hard to turn around. Great point, Wendy. Thank you for bringing that up. Somebody asks, when should I contact a lawyer? When you're thinking about divorcing, so you can plan ahead and know what your rights are and know how to be strategic and thoughtful about it, and hopefully approach it with the help of a problem-solving lawyer or law firm. We like to say that we try to help people solve these things efficiently, effectively, and intelligently without blowing up the whole place and running up gigantic litigation bills for our clients. So planning ahead, consulting early while you're contemplating divorce, or the first moment you have decided that this is something that's right for you and you need to do it, get that information up front so you don't inadvertently do something that's going to be against your self-interest. And also I want to say, because it came up in some consultations I had with prospective clients today, well-meaning friends and family have lots of advice to offer you when you say you're thinking about divorcing, or you're starting a divorce, or you're going through a divorce, but they know nothing about divorce laws, unless they are New York family court lawyers or family law lawyers, and they know nothing about your situation. So even if they know something about these, rules and laws, they don't know your situation. They cannot be in a position to give you good strategic advice. So just take that with a grain of salt. They mean well, and I'm sure that they have your best interests at heart. But more often than not, when people come in and say, my friends, my family, etc., my coworkers told me that I could do this or I shouldn't do that, and it's way off the mark, and people are relying on this advice from inexperienced people who don't know the situation or the laws, sometimes to their detriment. So make sure you get early advice from a good attorney that you trust. All right. Someone asked, can a judge make a spousal support order in a domestic violence case? And of course, that's possible in a domestic violence case, provided you are lawful spouses and not just intimate partners who never married. And you may recall that when Wendy went through factors to consider, domestic violence is a factor that could be weighed to adjust an award of spousal support up from the guideline amount, the formula result amount of maintenance, if the domestic violence interfered with that spouse's ability to earn income or become self-supporting or get education outside of the household. So we often see that the abusive spouse uses financial abuse as one form of abuse against the spouse, and may also isolate the spouse from other resources and things like that, isolate them from friends or supports. And so all of those things might mean that that person has had limited opportunity to advance their career or their job opportunities outside of the home. So definitely, that's a great question. You're going to also want to not just consult an attorney if you have a situation with a history of domestic violence or ongoing domestic violence. You are going to definitely want a domestic violence advocacy and support group in your corner if you're thinking about physically separating and or taking the legal step of divorcing somebody when you are in a situation where there's been domestic violence. I want to just say here, I have a background in I'm a recognized expert in dealing with domestic violence in the legal arenas, and it is leaving an abusive partner is the most dangerous time for victims of domestic violence. So you're going to want to make a careful plan, and if you have children in the mix, you're going to want to have a safety plan for both you and the children, so that you can protect yourself and your kids as much as possible when you're making the exit from an abusive relationship. All right, on the other side of the coin, someone asked, can you mediate spousal support? And the answer is yes, you can mediate everything having to do with your separation and divorce. So you can mediate custody, parenting plans, child support, spousal support, what to do with the marital residence, what to do with your retirements, what to do with your credit card debt, what to do with your student loans. The whole thing can be mediated. And if you have a willing person who's on the other side of the aisle who wants to go to mediation and settle these things out of court, then kudos to you. And we provide mediation services, both through Whitson Law Firm and Mediated Online Solutions. And we do a lot of this. We love to do it because it's cost effective, it's private, it's safe, it's respectful, it is quick, and the most affordable way you can get outside help in breaking up in all ways, breaking up emotionally, breaking up your kids in separate households, and breaking up your finances. And then that can lead you to have a comprehensive agreement that can be an easy, uncontested divorce where no one steps their foot in the courthouse door. Start to finish, you can stay out of court for the whole thing, save a lot of money and a lot of agony fighting in court over these things. And then someone asked, do you need to file a claim in order to get spousal support? And I want to say that both with spousal and child support, if you're entitled to it and you need it and you deserve it and you want it, you should file it early as possible, because your right to receive it starts the minute you file. So if you start by filing a divorce and you ask for spousal support in your initial filing, then you will be entitled to spousal support going back to the date you filed. Even if it takes several months for the judge to get around to addressing the issue and making a decision, it will go backwards in time to the date you first made a legal request for it. So think about that. That applies also in child support. So don't wait around and wonder and hem and haw. If you think you're entitled to it, get that petition in. You could change your mind later and withdraw it. But if you are entitled to it and you really truly need it, then get that petition in, and it starts the clock on your entitlement to receive support. All right, and then there was a question about how does spousal support differ from state to state, and does it matter where we file? Wendy and I don't know. I'm pretty sure it is different from state to state, but I can't tell you any more than that because I have not studied the spousal support rules in other states. So you're going to want to find a resource guide. And in New York, we have this online state court system, the official court website with lots of info. You might have a similar website resource in your state where you can find objective information that's reliable. Otherwise, hire an attorney for a consultation and get some information on your situation. So I think that's where we are. I don't know that there are any new questions that have been submitted while we're going along. So maybe I will take this time, unless Wendy, do you have any other things you want to mention based on anything I've just said?
I think you've covered most of it. The only little thing would be sometimes, parties, I find that, let's say if they file a petition in family court for child support, when they get there, they're like, oh, by the way, I'm not working, and I'd also want spousal support. If you don't have a petition for spousal support or child support before the court can only enter an order or make a decision on the petition they have before them. So you can always file for both child support and spousal support with one petition, and then have the court decide both on the same through the same petition.
Good point. And if you missed your opportunity to file at the same time, you can get another petition in later. So if you filed first for child support, not realizing you could also ask for spousal, you can file a second petition. They'll just be on different tracks, and you'll have different start times for those awards. But you won't be stopped from asking for spousal support if you forgot to put it in your first petition when you ask for child support.
Right. And also, sometimes parties first file for, let's say, child support in family court, and then they decide to file for divorce. So depending on the Supreme Court judge, the child support case may stay in family court, depending the length of time it's been in family court, what proceedings they've had. Sometimes when it's in the very early stages, the Supreme Court, if one of the parties files a motion to get the case transferred to Supreme, then the child support case will get transferred to Supreme, and Supreme Court will hear all issues, including child support.
Great point. Yeah, it can become complex navigating your way through the various options in the courthouse for you. But again, if you have legal counsel in your corner, you can make the right strategic decisions about where to start, which court you access first, and which court you access exclusively, if that's the way you want to go. So that's all good advice. So I want to wrap up by sharing a couple of things, some announcements. We're going to talk about some resources we'll be sending your way, and some upcoming things that you can potentially consider tuning in on for additional topics and additional information. So first, I want to say that we are very, very proud that we are a bilingual law firm. So tonight's presentation has been all in English, but we do have Spanish-speaking attorneys and support professionals at our office. So if you're a Spanish speaker who prefers to have your consultations and your legal representation in Spanish as the primary or only language, you can access that through Wiston Law Firm. We're very proud of that. We're also very proud to announce that we have been recently recognized as the first family law firm in the entire state of New York to become Certified Divorce Specialist Aligned. So Certified Divorce Specialist training is a program offered through the National Association of Divorce Professionals. It is designed for special training and certification for attorneys, financial professionals, mental health professionals, real estate professionals, and mortgage and finance professionals, and college planning professionals. So that we are best equipped to help divorcing parties with the unique challenges emotionally and legally as they're navigating through that system. So by being a CDS aligned law firm, it means that we have a commitment to have all of the people who interact with our clients and potential clients go through the certified divorce specialist training, pass an exam to become certified divorce specialized, officially certified. And so we're the first firm in New York that has the majority of our staff certified divorce specialist trained. And we are continuing as we bring on new staff to put more people through the training, because we are committed to doing the very best to offer good services for all of the various needs that our clients have. We know that you are human beings going through a difficult time, and we want to honor and recognize and support that. As I mentioned earlier, if you've registered for this and we have your email, you're going to get a bunch of resources. So there'll be some blog articles and other sources of information on the topic of spousal maintenance. If you visit whitsonlawfirm.com, there'll be a link in the Facebook feed, or mediatonlinesolutions.com. You can find a whole host of resources that are free to you to download at your leisure. So I have authored a book called Divorce Like a Pro, A Better Way to Break Up, and it's available for purchase on Amazon. If you like a hard copy or a Kindle or a paperback to touch and read, if that's your style, you could find it there. We offer a digital download version of it for free on our website, because we want to offer as much information as we can to people who need it when they need it. So if you're browsing how to divorce in New York at 3 a.m, you can download Divorce Like a Pro and read it at your leisure. You don't have to pay a cent. So there's lots of resources like that on child custody, grandparents' rights, cohabitation agreements, child support, and more. And we also have things in video format. So there are short topical videos, 3 to 5 minutes long, on how the benefits of mediation, or how to prepare your kids to meet with their law guardian, and all sorts of topics. So look at our websites, find us there, and we are on every social platform for both of those businesses. And again, we offer up resources and stuff in those places as well. We have some upcoming events. So we try to do Facebook Lives with some regularity. I can't promise they're once a month, but that's kind of the cadence we try to aim for. This weekend, you can catch me as a guest presenter on the Divorce Hour with Alyssa Panis, a very popular podcast for people who want to survive and thrive through their divorce. And I will be talking this weekend about the topic of cohabitation agreements, who needs them and why you need them. And you can catch it live on Saturday and Sunday at the CRN Digital Talk Radio, or after the live broadcast, it will be recorded and it goes out on Spotify and Apple Podcasts and all sorts of places. So it's the Divorce Hour with Alyssa Panis. We'll post some information on how you find that. So check us out there. If you missed the live, you can find us on that recording on Spotify. And then we're planning ahead for the fall a series of Facebook Live, more webinar formats. We're going to call our Divorce Boot Camp. It's based on the Divorce Like a Pro educational series, and we'll be breaking best practices for preparing for divorce into short boot camp segments, where we will actually be more interactive, and we can help you through your questions in real time, and so on and so forth. And then our next Facebook Live, with a date to be determined, but approximately a month from now, is going to be all about how to prevent your kids from becoming collateral damage in your separation or divorce, and helping them cope with adjusting to 2 households. So I will have family law specialist, not family law, sorry, family therapy specialist, John Haverlick. He happens to be my husband. He's a therapist with almost 50 years of experience in family therapy, working a lot with families, children, and adolescents. So I'll be talking about some practical legal tips, and he will be talking about things that are much more useful, and that is really emotionally how to navigate the separating kids into 2 households and setting up routines and so on and so forth, and beginning that co-parent journey, or if you're in it, how to make your co-parent journey work better from a licensed social worker family therapy point of view. So as all of our Facebook Lives are, that is free. We will be putting information out with specifics when we've pinned out a date and time, and we hope that you'll spread the word if that doesn't apply to you, and that you'll join us on that one if it does. So with that, I see we are at 8:01 and so we've almost stayed on time, but we're really close. So I want to thank you all for coming. I hope you found this useful. If you have specific questions you didn't feel comfortable asking in this forum, send us a private Facebook message. And if we have your email and you get an email from us, you can email questions to us and follow up if you have thoughts or concerns or anything you would like to ask us. I hope you'll consider consulting with us, and I hope you find our resources on the websites to be useful. If you do like them, please let us know. If there's something you don't see that you would want to see as a resource, let us know that too. We're always trying to improve what we put out there for free for people who need it when they need it. So thank you, Wendy Hernandez, for joining me tonight. Thank you, audience, for being with us. And if you're watching us on the replay, thanks for finding us on the replay. Good night, everyone.
Good night.